required after 5 years to purge those records. So in the last 5 years, the GBI has sent up to the FBI National Instant Background Check System nearly 10,000 mental health records. And in the same period of time, we've pulled back 2,000 of those records. Now, what this means is that the person is still prohibited from purchasing a firearm, but because of the purge requirement, we then pull those records back, so there's nothing in the national database that tells the gun seller that the weapon is not to be, the firearm is not to be sold. The records don't exist at the state level because they're pulled back and purged pursuant to state law. So what this bill simply does is take out the one sentence in existing law which requires us to purge these records after 5 years. And this will put us in conformity with what is required at the national level and put us in conformity with the rest of the states.
Questions for Director Keenan from members of the committee? Mr. Crowley.
Thank you, Mr. Chairman. Thank you, Director, and to my whip for the bill. Could you very quickly just walk us through if an individual who has gone through some type of a commitment is, I guess, for lack of a better term, made whole or gets better, what would be the process for them to approach, whether it be their local court or that jurisdiction, or to, I guess, make application to be able to own a firearm again, even, I guess, for home defense, whatever it may be that their need is?
Right. There's nothing in this law that establishes that.
That's
is
correct.
a redress process with a person who has a firearms license, and that's handled through the probate court. The way this process works is that there's a hearing before the probate judge, and the judge makes a ruling as to whether the person is to be involuntarily hospitalized or not. If they do that, they issue an order. It comes to the GBI. The GBI sends it up to the FBI National Instant Background Check, and it stays there until the state removes it.
Okay. Thank you.
Any further questions for Director Keenan? Seeing none, thank you, Director.
Thank you.
Would anybody else in the audience here like to be heard in opposition to House Bill 999? Sir?
Thanks.
Come forward.
Chairman Golick, members of the House Judiciary Non Civil Committee, thank you, and thank you again, Mr. Chairman, for allowing me to speak.
Sure.
Having not seen the bill or the LC number, a citizen, I have no clue what's in the bill, and well, thank you. Can I just look at it just for just a moment? Okay. All right. Now that I see what's in the bill, I would ask that the committee take into consideration that Congress passed Public Law 110 of 180 back in 2007, the Nix Improvement Act, which was an amendment to the United States Federal Gun Control Act of 1968 that incorporates a process by which a person can petition a court for the restoration of their rights. And to the extent that this bill doesn't address it like the predecessor version of this measure did, I would ask that the committee take that into consideration as to whether or not this bill would remove that judicial process or would not be as inclusive as the previous version would have otherwise allowed had the committee had been reading off of that LC number. And I do ask that the committee also take into consideration the fact that if the current state law does provide for the 5-year purge, that if after the expiration of 5 calendar years as measured from the date that the involuntary hospitalization ended as ordered by the probate court, I would ask that the committee take into consideration the appropriateness as a matter of state law as to whether or not that should be included in the bill as at least a rebuttable presumption that there should be a favorable finding under the Nix Improvement Act that the state may incorporate by and through the Georgia Probate Court Council and under its rules and regulations in regards to a petition that may arise from a litigant who is seeking to have their rights restored. I do believe, and I can't speak for previous legislatures that may have put the 5-year rule in here, but I do think that the purpose of the 5-year rule, if I had to guess, I would be inclined to say that it was to prevent someone from just being indefinitely unable to get their firearms rights restored, no matter even if their condition or if their situation had improved. Like Representative Gravely had mentioned, if they have been made whole or been made better, the purpose of the 5-year rule. And I understand I'm incredibly very sensitive to what's happened on a national scale and why the committee would be hearing this in such short order without going through the subcommittee first. But again, just for it to be run through one day and make this sudden change, I would be remiss if I failed to share my thoughts publicly in regards.
Thank you.
You're welcome.
Is there anyone else who'd like to be heard in any opposition to 999? Sure.
Mr. Chairman, members of the committee, my name is Susan Tate. I am the probate judge in Athens, Clark County. I am also the Weapons Carry License Committee Chair of the Council of Probate Court Judges and a former past president of the Council of Probate Court Judges. I just want to state that the Council of Probate Court Judges fully supports this clean version of the bill that Director Keenan and Representative Coomer have asked that the committee substitute today for the first version of House Bill 999, and would point out that the procedure that was set forth in the original version for a petition for relief from the mental disabilities in some ways duplicated the current procedure that we have for a petition for relief from disabilities, and in other ways contradicted the current procedure that's in Title 16. So I think that would create some problems. Plus it created a new purging procedure which would have, in some circumstances, required probate judges to order a person's name purged when we knew they were still prohibited under federal law from possessing a weapon. So I think the better course, if you wanted to do something with a petition for relief from disabilities, is to amend the one in Title 16 instead of layering a second procedure over that, the existing one, when they are duplicative and contradictory.
Thank you. Questions for Judge Tate? Seeing none, thank you, Judge.
Thank you.
Appreciate your coming down here. Is there anyone else who'd like to be heard in opposition? Although that really wasn't opposition, but anyone in opposition to House Bill 999? Seeing none, what's the pleasure of the committee? Ms. Bellinger moves due pass of HB 999. We're looking at LC 297989S. Is there a second? Second by Ms. Gonzalez. Are there any amendments? Are there any amendments? Seeing none, any further discussion? Any further discussion? Seeing none, all in favor of the lady's motion signify by saying aye. Opposed? The ayes. We'll record one voice in opposition. The motion is adopted. Thank you, Mr. Coomer. No. Yes, sir. Yes, sir. Thank you very much. And thank you for the bill. Is Representative Donahue still here? Oh, he's right over here. Representative Donahue has House Bill 860.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. I have before is HB 860 by LC 297994 ERS. And excuse me, my voice is kind of breaking up with whatever the sinus is. This is basically what we call the social host bill. And with that, our main intent, if some of you have looked over the bill or had the pleasure of sitting in on the bill, we've changed it several times. What we're trying to do is just hold a little responsibility for someone that makes a decision that's an improper decision as a social host. And with that, a social host is no one shall knowingly organize or permit any person to furnish or alcoholic beverage to any person under 21 years of age. Already in code, we have the code that you can't buy alcohol or you can't have alcohol if you're under 21 years of age, unless me, as my son, wants to sit and watch a ball game, and if I give the permission for that child under my care, it's okay. Now, presently, some people keep asking me that, and I just wanted to kind of make sure that's clear. I have a right as a parent to make sure that my son, if he wants a beer and he's 17 in my home, he can have that beer. I chose not to do that, but however, that's available. With this, what was happening, we were having people that were having their daughter and son in high school that were graduating, and where this come about, the parent would say, we're going to throw a party. Bring your whole class, we're going to provide alcohol. And when they did, of course, you started having seniors that were 17 years old coming to a party with alcohol. We had seniors dating juniors, sophomores. The party grows larger. We have younger people there partaking. And what was happening, we realized that this was a crisis that was growing continuously. I have two people here, Brittany Newton and Ann Murray, and there were Voices of Prevention, and they have studied this quite a bit. I would like, if anything occurs, that they can speak to the comment of a question, etc. We had changed on this bill. If you'll look down in the lines 22, where it says 19, it'll say 1A, no person knowingly, directly, or through any person shall furnish, cause to be furnished, or permit any person in such person's employ to furnish any alcoholic beverage to any individual under the age of 21. Then 22, it says no person shall knowingly organize, permit, allow, or host any social gathering of two or more individuals on any property or in any vehicle or vessel that such person owns, rents, or borrows, or over which such person otherwise exercises any control at which any alcoholic beverage is consumed by any 21 individual under 21 years of age. On the previous bill, we put knowingly and consumed in the line 22 is knowingly and 25 was consumed. Excuse me. As we continued the bill, in our last meeting in the subcommittee, there was an opportunity to strike by the vice chairman lines 32 and 30, so we took those lines out, and thank you very much for your direction there. So when we look at now 32, lines 32 says, this subparagraph shall not be deemed or construed to affect or limit the powers of county, municipality, or other political subdivision of the state to adopt ordinances or resolutions prohibiting the conduct described in this subparagraph with their respective limits. Then we changed, as we come down now, you'll look in line 37, the end of 36, after property, we added so long as such owner, of course, was in there, or landlord is not. We added the word not in there also. Some of you, of course, was here when we went over this. Some of you weren't, so I'm just kind of telling you where we are now on what we put in our quite a few draftings of this bill.
Questions for the author? Seeing none, Chairman Setzler is the subcommittee chair for this bill. He's not here right now. I know Chairman Reeves worked on it in subcommittee, so we're going to go ahead and have Chairman Reeves give the subcommittee chair report. Vice Chairman Reeves.
Thank you, Mr. Chairman. We worked extensively through this. I know there's been a lot of, this bill has been around for a couple of years now, 2 or 3 years, and we worked through a lot of the challenges dealing with, number one, whether or not the standard needed to be knowingly or something less than knowingly, a reckless, almost gross negligence type standard. And where the committee landed was, especially in light of the consistency of 1A, no person knowingly, that we felt that criminal liability was best imposed in this if the adult parent or whoever it is that's providing the house where this social gathering will take place, that they knew that that was what was intended to go on, and further that they knew that alcohol was being consumed. One of the things that I came to understand after a careful reading and being pointed towards in the bill is that first violation of this would be a citation with a $300 fine.
That is correct.
Unless that adult was intoxicated to the degree that the officer felt the need to arrest him. We also had stricken a line or two lines that are part of the affirmative defense but seem to create what would be potentially an obligation to call the police on what may be your own children. And I just think that provision gave heartburn in its practical impact and potentially could, damage the bill's ability to, I think a lot of folks would have concern over that. So that was removed. So I'm comfortable. I think we've landed in the right spot on this. And I think I can say in Chairman Setzler's place that we're comfortable with this bill.
Well, thank you. I appreciate that. Mr. Bodie.
Yes, thank you so much, Mr. Chair. Representative Donahue, we appreciate you bringing this bill and explaining it to us. Now, I feel like the purpose of just reading the bill is to kind of curtail some of these house parties that are happening. And I'm very sensitive to that because in my district, we had a young man that was actually murdered at a high school graduation party out in Douglasville a couple years ago. But I am kind of concerned where we have the language in 23 that applies to any vehicle or vessel. I think that might be broadening it to a place where it might be kind of hard to distinguish. And I feel like if we're going to focus on property, and I like where the subcommittee brought in there where the municipalities and innocent owners are not going to be affected. But I think when we talk about vehicles, that kind of takes away from the breadth and the purpose of the particular statute itself, to me. And by utilizing that language, as far as the vessel is concerned, vehicle, what were you trying to accomplish with that particular language?
I think when we first started, a vehicle or a vessel could be a houseboat. You could have a houseboat party. That happens quite a bit to where in a vehicle you can have a motorhome. We have different things that basically falls up under that narrative, I guess, of the description, and that's the two would come to my mind. We had some instances the same as you're talking about. We had a young man that was a rising football star that was a very smart young man in Hall County that went to one of these, and he was a junior. And all of a sudden, he was so intoxicated, he realized that he needed some help, so he went to the vehicle and passed out in the vehicle. His friends came upon him, saw what had happened, started throwing water on him as a joke and prodding him. He was trying to get away from the situation, but what happened? He had a pocket knife, and he stabbed his best friend several times. Luckily, his friend lived. But however, that's changed this young man's life to where he is now behind a fence. He had colleges everywhere wanting to offer a scholarship. He is basically now speaking against what's happening here, as he being an underaged young man that went to this party. He made that decision that has changed his life. But we have ran into story after story after story of this happening. And that's what Brittany basically represents and voices. And Miss Murray, not to be confused with a Canadian singer, and Murray, she pretty much has devoted a lot of time into this. So to answer the question, that's the way I would see it, would be as a motorhome or a houseboat, which we have a lot of houseboats up in Lake Lanier, and they have parties continuously there. Did I confuse you a little bit more on that, or did I?
No, I'm thinking in my head I may offer a friendly amendment towards the end just to kind of define that. But I see exactly where you're going. I just don't know if some law enforcement may see vehicles and it may get thrown off a little bit. But I definitely see that explanation.
Just as a
Vice
counter,
Chair.
thank you. Sorry, Mr. Chairman. Just as a counterpoint, I think that the applicability of this is, I don't see any difference in if an adult provides a boat for a bunch of teenagers to go out on and knows that they're going to be drinking on the boat and they're not 21, or an RV to go to the tailgate or whatever it may be. I think it's the same conduct it's the same conduct, and I think it is applicable, and I think it's appropriate personally to stay in the bill.
Ms. Gonzalez.
So thank you again, Representative Donahue. I know I've asked lots of questions.
And that's okay. Thank
But
you.
I want to clarify one thing, because a number of times in subcommittee and also here, you've mentioned, as well as Chairman Reeves, the idea that the first citation is just $300. But if we go to line 104 to 105, it says, starting at 103, I'm sorry, shall upon the first conviction be guilty of a misdemeanor and shall be punished by not more than 6 months imprisonment or a fine of not more than $300. So it is at the discretion of the officer, right? So we can't guarantee that the first offense is just a citation.
The intent would be $300 unless that officer found something already in code, meaning other laws that are presently in code broken. The occupant was intoxicated beyond control, and he felt that need, something else happened. Now, with that also, I would think would continue over to, if I have a parking ticket's $100, and if I do not show up or pay that parking attendant that ticket, it can tell me that I am subject to 3 months in prison, et cetera. So I think that's an extenuation, and I can be corrected by an attorney here that might know that different way. I understand that. That's the way I would read that.
Is that the part of convicted of violating paragraph 4 of subsection? Is that?
Yes, ma'am.
Okay, thank you.
Any further questions for the author? Any further questions for the author? Seeing none, is there anyone in the audience who'd like to be heard in opposition to House Bill 860? Seeing none, what's the pleasure of the committee?
Move to pass.
Vice Chair moves due pass of House Bill 860, LC 297994 ERS. Is there a second? I just wanted to get it. That's all right. Need a second. Is there a second? Sorry. I say again, is there a second? Mr. Bodie, did you want to be recognized?
Yes, I wanted to extend an amendment, but I will wait on the second of the motion.
Okay. So we have a motion of due pass by substitute of HB 860, LC 297994 ERS. We have a motion by the Vice Chair. Mr. Bodie has an amendment. Is there a second that someone is willing to make in order for Mr. Bodie to be able to speak to his amendment? Perhaps a curing amendment. All right, Mr. Donahue, I don't hear a second.
Yes, sir.
I do still have a quorum. That doesn't preclude us from potentially getting back together if there's an issue that you want to address with one or more individual members of the committee. Since we've scheduled this and we've had a good discussion on it, if there's a mechanism for curing a concern that you feel you can get to and still maintaining the integrity of your bill, the chair would look at scheduling a fairly quick meeting in the ante room since we've already been through it, if we can get to that point. So I just
Thank you,
want
Mr.
to
Chairman.
offer that in the interim between now and tomorrow morning at some point.
Well, I thank you, Mr. Chairman.
Thank you.
I'll take that posture.
Thank you.
No, I did, I made the motion. I can't move and second. But you can do a second and an amendment. You can do it a second and an amendment. No, chair can't do the second.
Thank you for your patience. We're adjourned.